To this story now, at least one of the 5 accused in the Senzo Meyiwa murder trial has confirmed applying for the Section 174. Linda Mnisi will explain what that is for us. The accused applying for a discharge because they believe there are no reasonable prospects of a conviction. Now, proceedings in the Pretoria court were adjourned last month after the state closed its case. Let's talk now to Linda Mnisi, as I mentioned, who's going to explain all of this to us. Linda, good evening to you. Let's start with what today's court proceedings were primarily about before we speak about that Section 174.
Well, essentially, you have to remember that the state has closed its case, right? And that meant that the defense had 2 options: to open their case, call their own witnesses, or to apply for a Section 174. What is a Section 174? When an accused person at the end of the state's case believes that there are no reasonable prospects of a conviction, looking at the state's case in this particular matter, then they can apply for the matter to be thrown out. It's called a discharge application in terms of Section 174 of the Criminal Procedure Act, right? So in the last sitting, there was a decision to go for the 174 application by the defense. But the issue there was the funding. Would legal aid be willing to fund it? And today, we were going to learn about whether or not legal aid will fund this application. But of course, they would have had to engage the lawyers first, right, about the outcomes of their request. And I want us to start with the basis, really, around the issue of the 174 application, because if you believe that there are no reasonable prospects of a conviction, you believe there is no evidence, even on a prima facie level, right? So, what the issue is are there prospects of success for this particular 174 application? Let's take a listen to what legal aid had to say to them.
We have had discussions with our instructing attorneys, legal aid, and in particular, Mr. Ntanzi, Sibia, and others, my lord. My lord, briefly, I'm not going to talk about finances and all of that because that's matters that should be in the private sphere. So I'm not going to talk about that, my lord. My lord, my instructions simply were still to proceed with the application for Section 174. However, having discussed the matter with our instructing attorneys, they feel that we stand less chance in succeeding the merits thereof. That's what they've just told our clients, that we don't have a leg to stand on the 174 application, my lord. Then I'll have to take instructions again from Mr. Ntanzi, having been advised that we don't stand a leg on the 174. Yet we are given the green light to go, but the view is that there's no leg to stand on, my lord.
All right, so that seems clear enough. They are told, I guess, by the state, the prosecutors, that they don't stand a chance of succeeding in this application for charges to be dropped. And so the next logical step then is to find out whether this will be funded by the state, because legal aid is where this all comes in now, or is where they come into the picture.
In fact, they're told by legal aid, who's funding them in this particular trial. They went to legal aid to see whether or not legal aid would be able to fund this particular process because of the manner in which legal aid funds them, the model in which they use. And a representative from legal aid came to court today. And what they're saying is that they're not stopping them from applying for a Section 174 application, but what they will not fund them for is the 4 weeks preparation that Advocate Charles Mnisi wants. He basically wants 4 weeks to prepare for a Section 174. And this legal representative from legal aid explains the tariff and how they are paid. Take a listen.
A decision was made that they won't fund them. We won't stop them from doing a 174 because that is part of the Criminal Procedure Act. But the Constitutional Committee said that they're of the view that to pay an additional 4 weeks to prepare for a 174. They weren't amenable to that.
Yeah, okay. But you're prepared to fund an application for 174?
Well, it's the appearances,
Yes.
and in terms of the tariff, they obviously are entitled to fees in terms of the tariff. In terms of the tariff, they've got 2 days, 2 hours preparation per day, plus obviously the court appearance. But in addition to that, legal aid's not prepared to give the additional amount.
All right. So to understand this better, Linda, is what is being explained there that legal aid does not have a problem funding their application, but it's the time that is requested for which to prep for this. And is that all about managing, I guess, the limited resources of the state? Because that's who legal aid is. These people don't have money to fund lawyers, and therefore the government must fund their legal fees.
Yes, essentially, they're basically saying the funding model and the tariff that they are on allows for, payment of 2 hours of preparation as well as the appearance. Now, it seems, the request here is for legal aid to fund the preparation, the 4-week preparation, and they're saying they're not amenable to that. In fact, there is a committee that was deciding on this, that sits and decides on these particular aspects. In fact, we reached out to legal aid a couple of days ago, and they, sent a response yesterday indicating that when a matter is complex, right, they would basically apply what is called an increased tariff to accommodate for the complexity of this matter. And the representative from legal aid explained that they are on the increased, tariff, but what they're not amenable to is the 4 weeks preparation. They're clear about where they stand about this Section 174 application. It's not going to succeed. So given, from what they're saying, they don't think they've got a leg to stand on, which I must clarify. They don't think they've got a leg to stand on. The prospects of success are very slim. So given this, given what they are saying, the question one would wonder is whether or not there is a point to go ahead. But of course, one needs to also remember that it is their right that they can exercise. So obviously at this point, the question is, who amongst them is going to go for Section 174? We know for a fact that Advocate Zandile Mshololo will not be applying for a Section 174, but the lawyer for accused number 3, that's Zithulile Nxumalo, will be going for a Section 174. The 2 others, it's really unclear. Well, I'm talking about the lawyer. It's really unclear because their position wasn't really categorically stated in terms of, whether or not they will go ahead. So this matter will come back on the 25th for arguments on the Section 174. They're given until the 15th to file papers.
All right. I guess those 2 are the clients of Advocate Charles Mnisi.
Advocate Charles Mnisi, as well as, Sipho Ramasipile.
All right. Thank you very much, Linda Mnisi, clarifying things for us there.